Hello, fellow New Yorkers. You are in for a real treat today. I am going to show you how to fill out a preliminary conference order in a New York matrimonial case and explain to you a little bit about what it means. So take a look on your screens. This is the New York State preliminary conference stipulation/order for all contested matrimonials. This particular form, as you're viewing it today, has been in effect since at least July 1st of 2022. So let's go over what this form means. This is a form that is typically filled out on the first court appearance. When you come to court, either you, if you're representing yourself, or your attorney or attorneys will start filling this out. And you're typically going to get a chance to look this over, but definitely makes sense to check it out before you get started. So let's start from the top and work our way down. You'll see Supreme Court. We'll pick my home county, New York County. Obviously names of the litigants: Joe Schmo against his wife, Joan Schmo. You'll have your index number. The index number is your identifying number for your case, so that could be anything like 1, 2, 3, 4 of 2023. Part number is whatever your judge's part is. So let's say part 11. Presiding judge, the Honorable Judge. I'm not even going to make jokes about this one. Parties and counsel appeared before this court, such and such date. Here we get into the background information. Now, the court doesn't really know exactly what your case is about. It's your first appearance. They need to get a sense of who you are. What are the dates in this case? Are there kids involved? What kind of outstanding issues are they dealing with? So you have your date of the summons filing, the date that it was served, assuming it was served. Otherwise, you might be dealing with a default where you typically will not have to fill out a conference order. Your date of marriage, any children that you might have. So Joe and Joan Schmo have a young son. His name will be Jim Schmo, and you put in little Jimmy's date of birth, and you start working your way down. Attorney information. For those of you who don't know, I'm Attorney Leon Mindin of the law offices of Mindin and Mindin, a New York divorce attorney. Opposing counsel's information is here. This is pretty important for the court. Any future notices that might need to be sent out, court's always going to go back to this page. Important. The court has received copies of a couple of things that they want to see early on in the case. Certainly statement of net worth. I'll have a separate video about what that is, but the short version of it is a statement of net worth is a sworn statement that you're going to be submitting to the court, which outlines all of your assets, liabilities, the various property that you might own, identify what the debts are. This gives a good snapshot of what the finances are so that the parties can start working towards financial discovery and always working towards a resolution. Part of statement of net worth, typically you're going to have to include your most recent tax return and a copy of your signed retainer with your attorney. So the courts will definitely want to see how much you're paying your attorney. This is relevant for any future counsel fee applications, so definitely something that either you or your counsel will have to attach. Going on, we have the orders of protection. Some cases, unfortunately, will have prior orders or existing orders. This will update the court. If there's any necessity for an interpreter, you'll put that in here. Joe and Joan Schmo speak English, so they will not require anyone. Moving on to the next page, please identify and state the nature of any premarital, marital, separation, or other agreements and or orders which affect the rights of either of the parties in this action. So most commonly, it'll say prenuptial agreement dated, January 1st of 2012, and then any other, maybe perhaps if there was a separation agreement that was entered into, the date that agreement was finalized. Perhaps if there's anything that might be potentially related to the matrimonial action, such as a bankruptcy or some sort of ongoing proceeding that the court should be aware of, that's the place where you should put it. This doesn't happen often, but it certainly does. If there is a prenuptial agreement, Sometimes there's a challenge. The agreement wasn't entered into validly, or there's some sort of defect in it, or it's a sham. Whatever the case might be, if there's any challenges, typically at the preliminary conference, the court is going to set a date by which the parties will have to contest the prenuptial agreement. That's a whole separate issue in of its own. Moving on, the grounds for divorce. Now, New York has 7 different grounds for divorce. Since 2010, New York has been what is known as a no-fault state. So under domestic relations law, subsection 170, sub 7, you would be most likely proceeding under the grounds for divorce of irretrievable breakdown of the relationship having lasted at least 6 months. So there's usually no issues with the grounds for divorce. Typically, this will be resolved. Judges absolutely hate it when someone starts bringing up, there was cruel and inhumane treatment or adultery. They don't really want to hear it. So, the purpose of going to court is you definitely want to move your case along as quickly as possible. So that is definitely something you want to mark as resolved as often as you can. Rarely will the grounds be unresolved, at least in my experience. Grounds for divorce, going back, we have the complaint. Sometimes divorces are commenced with what's known as a summons with notice. The summons with notice does not always have the same items listed in as a complaint. Complaint is a more formal document that is usually signed by the plaintiff. So whether that was served or will be served, usually you and your attorney will pick a good date. An answer, responsive pleading, which typically is answered within 20 to 30 days. So you pick a date here. And if any counterclaim, you also pick a date 20 to 30 days after the responsive pleading. Going on, the issue of custody. If there's any children, any matters regarding custody, decision-making, parenting time, you're going to mark it whether resolved or unresolved. Same goes for decision-making. If the parties are entering into an agreement, the agreement will be provided to the court by a certain date. If the parties have not gone to that point and are still early in their negotiations, then this will be marked as unresolved. Don't be scared to mark things as unresolved. That's absolutely fine. These things certainly do take time, and the court will afford you a little bit of time to move that along. Then we come to the matter of an attorney for the child or attorney for the children, frequently known as an AFC. AFCs, this is going to vary from judge to judge. There's really no kind of specific way that I've seen it handled. Cases where it's very contentious and there's really no resolution, or there's orders of protection, ACS involvement, you're going to see a judge appoint an attorney for the children. Those attorneys are not free. The litigants will typically have to pay a separate retainer proportionally based on their incomes to that attorney. You don't get to pick, so it's there's a panel. Whoever's on that panel and is on rotation will get assigned to your case. From that point, once you move down this list, I have rarely seen forensic checked off in the beginning. Forensic evaluation is really when parties cannot reach any type of agreement, or there's some serious psychological issues going on, or some abuse that a parent is alleging that the other is committing. At that point, the court will issue an order for a forensic evaluation, which is extremely expensive, time-consuming. This is typically reserved. So you won't see this right away, but it is something that could come up later in your case. And same goes for the attorney for the children. If the court is not going to immediately issue it, or they don't see a necessity for it, sometimes you have babies and they're like, we're not going to give the baby an attorney. Baby can't really tell us much. They'll reserve that, and then you'll cross that bridge when you get there. Moving on, you'll get to the financial issues. This is really important because you don't want to make a mistake here. Whether you are seeking maintenance or spousal support, as some people call it, child support, distribution of assets, counsel fees, unless you have something in writing, all of this is marked as unresolved. Whether you want spousal support or not, typically unresolved unless it's been waived in a prenup or it's really a non-issue. Child support, if it hasn't been formally resolved by a court order, unresolved. Equitable distribution of assets, unless you've already entered into a separation agreement, or you just don't have anything, at which point I don't know why you're contested, mark it as unresolved. And same thing for counsel fees. Typically you want to reserve that right in case your matter goes haywire and you might need to make an application. Any other causes of action and ancillary relief that are unresolved. So if there's any other relief that could be sought, this is case by case, so I'm not going to get too deep into this, but if there's any other unresolved issues, this is the place you're going to write it in. Any additional issues, you have a little space for this, a pendente lite relief, a next order stipulation. If there's a motion that was heard at the same time as a preliminary conference, which happens sometimes, there's a decision from the judge, then they'll attach that order, or if there was a agreement on the record between the parties as to how to handle something pending the litigation, they will sign a short order or some sort of stipulation, and this will be attached. Then you're going to get into the discovery. Most of this involves the production of documents. It varies from judge to judge, but typically you're going to get 30 to 45 days from the date of this order to start providing financial disclosure. I usually say 45 days. I think 30 days is a bit unrealistic for a lot of people, especially when there's a lot of paperwork that has to be gathered. Time period could really vary. That could be as broad as a couple of years, or as narrow as maybe a year. If it's a short marriage and you don't need that much of a look back period, you might ask for a short amount of time. So typically start out with 3 years for production. So we're looking at federal, state, local tax returns, credit card statements, checking account and the checks, brokerage account savings, savings account statements. Others could be things like business account statements, other kind of annuities or other assets that a party might have that might not necessarily be covered by brokerage account statements. So this is where you need to speak to your attorney, and your attorney needs to know more specifics about your case. Then additionally, service of notice for discovery and inspection. There are some limits now. The New York matrimonial parts have adopted the commercial part rules. Previously we used to receive these thick stacks of demands for discovery and inspection. Most of them were completely bogus and boilerplate, and a lot of attorneys would use this to harass the other side. Say okay, you wanna go through discovery? Let's do it. I'll send you about 1,000 demands, and you could comb through each request. And if you don't, I'm gonna drive you crazy with additional demands and try to complain that you're being unresponsive. Those games have ended, thank God. So service for discovery and inspection is limited. There's only a few items that could be requested. Oftentimes, I think it's duplicate of the discovery demands here within the document production, but some attorneys will still send it out. So parties will pick a date. Usually it's within or shortly after this 45-day period in the document production. Then responses, counsel will usually pick a day about 30 days out from there. Interrogatories is a kind of written substitution for a deposition. You don't always need to do this right away. Some judges will make you pick dates. Oftentimes, attorneys will either say, of course, case specific, but most attorneys will say, I don't do interrogatories, especially if they're limited to 25 questions at this point. They'll say, I don't do interrogatories, or after I get the discovery responses, I'll reserve my request to serve that. Then moving on, you have depositions. Depositions in matrimonial cases, it happens. I can't say every case, but typically we will pick dates. just to reserve that right. So we'll either select a date jointly, or we'll reserve that, and then we'll cross that bridge at a future date. Again, this is going to vary from judge to judge. Some judges will make you, some judges don't like you reserving. So you have to take it step by step. Electronically stored information, privilege logs. This is by case basis. I'm not going to get into that. Valuation of financial experts. If at your preliminary conference you need to pick a appraiser, or you need to appraise certain assets, you'll do it here. If there's real estate, you'll see it right here. There's real property, so you'll check this off. Joe and Joan Schmo will split the cost 50-50. That's not always the case. You split it generally pro rata based on what the earnings of the parties are. But if there's any business interests, professional practices, deferred compensation, stock options, intellectual property, or anything else that could be valued or needs to be appraised, collectibles, Pokemon cards, baseball cards, whatever, guitar collections, whatever it is you have that might need to be appraised, we'll typically identify it here, and then the court will either order the parties to use an appraiser that's already approved by the court. So they'll typically have someone that covers these items here, A through F, but if it's something that's a little bit novel, perhaps jewelry or something else, you'll typically have to agree with the opposing side as to who's going to be the appraiser for that. So you pick your dates, when the reports are due by. Again, you could also reserve on the right to this if the judge will allow additional experts. There's a health insurance notice stating that parties cannot remove the other spouse from their insurance policy during the pendency of a divorce, and once a entry of a judgment of divorce is complete, then they are eligible for COBRA coverage. This reminds people that there are automatic statutory restraints about selling property. This is something that should be described and explained to you early on in your case, but this is just a recital of that. Parent education is a little too far down. I don't know why they don't put it higher up, but some judges will send you to parenting classes. A lot of judges will. They'll have you do an online parenting course, and you'll have to upload a certificate to the court to satisfy compliance. So if the judge will order it, or will just provide information, you'll check this off. The court has moved on to some presumptive mediation where possible, assuming there is no prior order of protection and both parties are interested. There is a program in the New York State courts through Judge Sunshine's initiative that allows some court-appointed mediators to provide 90 free minutes of mediation. And if that's helpful, then the parties can go on and they can pay privately. Mediation's helpful. I think for some cases it's good, but it's not for everyone. So you have to talk to your attorney or really know who the other person is before you even want to engage down that road. Then we have the notice of guideline maintenance. This is actually served with summons for divorce, so nothing new here. This is the statutory formula as to how spousal support is calculated. It just gives each person notice. That continues on into the next page. And then there's some pre-trial conferencing and pre-trial requirements. So if there's two attorneys, the attorneys have already conferenced, and a couple of other pre-trial matters that have to be considered. Usually doesn't involve a lot of insight early on in the case. This is really getting too far ahead. Note of issue. Some judges will pick a date where all discovery has to be completed by. They're supposed to, but not all judges do. And then you make it to the end of this very long form that will certainly take some time to fill out. It will be signed by both parties, counsel, and then it will be sent to the judge, and the judge will review it, will make some comments, possibly make some edits, changes, and then will advise all parties of their legal rights. So if you have a preliminary conference coming up, I hope that this was insightful for you. If you do have a preliminary conference coming up and you don't have an attorney yet, and you're within the 5 boroughs of New York City or Nassau and Suffolk counties, we are here to help. My name is Leon Mindin from the law offices of Mindin and Mindin. You can book a call with me or my staff to go over your case, and hopefully something we could help you out with. So feel free to subscribe and book an appointment with us on our link below.